Welcome to the Fixer Podcast.
Hello and welcome to The Fixer with experienced attorney and author John Tatoian. Thanks for joining us today. I am your host, Kevin Rosenquist, and today we're going to talk about some various topics including debt collection and some of the mistakes that businesses sometimes make when they are trying to recover funds. John, great to see you again. Thanks for being here.
Thanks. Very nice to be here.
So debt collection, it often has a negative reputation. How do you approach debt collection ethically? And what advice would you give to businesses trying to recover funds while maintaining good client relationships?
My approach is initially when I'm retained for a debt collection matter is to try and engage in what I call nonviolent communication, which is to identify a goal, a mutually agreed upon goal, both parties can agree upon, and then figure out a solution to achieve that goal. So you try and take away the adversarial nature of it, where you're not saying, okay, when can you pay the money? You owe $50,000. If you don't pay, we're going to sue you. And that's a very, very adversarial approach, and it puts people on the defensive. It can backfire. But if you try to approach the situation where, how can I help you? You owe $50,000. The goal is to get you to pay this money. We both agree on that, if they do agree. Or the goal is to avoid, usually the goal is to avoid litigation, because nobody wants to go through the litigation is unpredictable. It's aggravating. It's time consuming. It's expensive. So they want to avoid litigation. So it's pretty easy to get them to agree on that. That's easy. Whether they agree whether they owe $50,000 or not, in my example, is a different story. So you try and to an understanding of what their financial picture is and try and figure out a solution where my client is happy, because that's where my allegiance lies. That's like my duty of care. It is towards my duty of loyalty and care and obedience. My fiduciary duty is toward my client. You have to approach it very delicately. You can't overreach too much or go too overboard. Like, you can't loan the guy who owes $50,000 the money to pay your client. That's an extreme example, but you can go back and forth, and you can try and, through different techniques, you can try and convince the debtor that it is his or her its best interest to just resolve this amicably, peacefully, out of court, without any litigation. And usually, probably 90% of the time, if the person is reasonable, right, sometimes even if they're not reasonable, they'll come around to see that they do not want litigation because it's unpredictable, and that a peaceful settlement will resolve the situation, and you'll get a predictable result, and you won't have to go through all the craziness of litigation. And inherent in those communications is a strategy that I use where I find the weak spot of the debtor, and I try and find the Achilles heel, and I try and very, very subtly let them know that I know what their Achilles heel is. So, like, I don't come out and say it, because that would be, you don't want to trigger the person, right? Be adversarial, but you want to impart to them that you know what they know. Depending on how weak the Achilles heel is, they'll succumb much quicker. So obviously, if the debtor, you run into situations where the debtor is what's called judgment proof, where if you get a judgment, go to court, get a judgment, the debtor doesn't have any non-exempt assets that you can levy upon. Those are the most challenging. Those are the ones where you tell the client to basically, if it's appropriate, to write the debt off, because they'll make more money doing that than they will chasing a debtor that has nothing. So if the debtor has something as in judgment proof, then I, excuse my French, an FU, they tend to go pound sand. They have an FU attitude. But I have to get a little bit more adversarial and have to press them a little bit further. Not in the, maybe irritate is the wrong word, but I know how to be subtly irritating. There's an old saying by Sun Tzu, The Art of War. In The Art of War, he says, when irritate your enemy, and when equally matched, fight. If not, retreat and regroup. So I try and irritate and confuse the opponent. The peaceful, nonviolent communication method doesn't work. And then they usually end up doing stupid things, and that just kind of gives me more ammunition to accomplish the goal that I want to accomplish for my client. So just, it depends.
Yeah. I really want us to bring back pound sand. I miss that. Not enough people say it anymore. I think it's hilarious. I love it.
Yeah. Well, I mean, it's very, very rarely have I had people, I mean, eventually they come around.
Right.
They know, I mean, if they Google my name, or they figure out who I am or my success record or whatever it is for whatever reason. I mean, even just being a lawyer coming in, it's like, I always tell clients, it's kind of like being in a bar and there's a fight and somebody at the bar says, knock it off. The people that are fighting they're gonna keep fighting. They're gonna say, go jump off a bridge, F you. But when a police officer shows up and tells them to stop fighting, they might be more inclined to listen. So right. When a lawyer calls up, the lawyer is the conduit to the most powerful person in the United States. And that's the guy that wears the woman that wears the black robe and the gavel. Their attitude tends to change very, very rapidly. It's made that way.
That's a really good point. What are some of the common mistakes that you've seen businesses make when they're trying to negotiate disputes?
I think the most common mistake that I've seen is they get too emotional, whether it's anger, belligerence. They are very angry, different gradations of anger, let's put it that way. So they let their emotions rule over logic in a methodical approach, in a strategic approach. So the emotions and the anger mitigate or vitiate the strategic approach and the logical approach, which yields losses. And that's when they call me. Somebody owes you money and somebody owes you $10,000 or $20,000, and you have a wife and a kid at home, and your wife is pregnant, and you have a business to run, you have payroll to meet. That emotion and that anger comes out in fear. That's where anger comes from. The baseline is fear. You're afraid. It's economic fear, really. It's not physical fear. It's economic fear. You're not going to see Warren Buffett getting angry at anybody. He has $120 billion. The more economic resources that you have, usually in my experience, probably 95% of the time, the less emotional that you're going to be.
Right. Yeah.
You can see things more clear. It's almost like when you go for an eye exam, you can't, if everything is blurry, and when they give you another set of glasses and change your prescription, and you can see everything clearly. Well, that prescription is money. You have $100 million in the bank. You're not going to be very angry or mad at anybody. You're going to be hugging and kissing everybody. You're going to be very logical and very methodical, and you're going to accomplish your result. And it's a vicious cycle, because the more emotional and angry you are, the less chance you have of accomplishing your result, and we're just going to dig yourself deeper and deeper into a hole. So you have to somehow stop that emotion and anger, retweak your mind, which is difficult to do in business.
Yeah, no doubt.
In personal relationships too.
Yeah, you're right. 100%. 100% is. We talked last episode about you've got some pretty, vast investments and assets totaling millions through John Tatoian Enterprises. How does your experience as a business investor influence your approach to legal negotiations and business acquisitions?
The business model that I came up with was from, and I know I mentioned him a couple times, but comes from Berkshire Hathaway. It was Charlie Munger, who passed away, I think about a year ago. Who was Warren Buffett's right-hand man. He was a lawyer, and he was a big part of Warren Buffett's success. And he structured Berkshire Hathaway, or advised Warren Buffett on how to structure it. He was very instrumental in it. So I just kind of copied that model, that paradigm. So the baseline of my model in creating wealth is information. I try and access information, and I try and use that information as leverage, so maximum commercial advantage, in order to generate multiple streams of income. So you access the information, you use it against your opponent for maximum commercial advantage in order to generate multiple streams of passive income where you don't have passive income is where you don't have to exchange your time for money. You're exchanging your capital for money. So that's the baseline. And to do that, you set up a number of different entities that generate passive income. And that's the structure or the paradigm that I created with John Tatoian. That's the model that I use.
Your approach.
How do you access that information? Well, you do a lot of research. You pay private investigators to access information on people. So there's a lot of work involved in accessing that information and knowing how to use it. And you have to be very careful. Just as no small caveat that when you access information, say about an individual, let's say, you have to be careful of getting into violating the rules of professional conduct or what we call blackmail or extortion. You want to stay far away from that. You can't find out information about somebody and then say to them, well, if you don't pay me money, I'm going to make this information that's disparaging, that's private, I'm going to make it public.
Yeah, that's not allowed.
Yeah, you can't say, just like you can't say, well, if you don't pay me the money that you owe me, I'm going to come and beat you up. You can't say, I'm going to, pay me the money, I'm going to call the cops and tell on you, that fill out a complaint against you that you stole your neighbor's cat. It's called extortion. It's also a violation of the rules of professional conduct. You can't, when you're involved in a dispute with another party that's represented by a lawyer, you can't say to the lawyer, if they do something that's purported ostensibly unethical, you can't say, look, I'm going to report you to the bar for this unethical, what I believe to be unethical behavior, to intimidate them and to gain an advantage in the civil dispute here involved in it. I forget what rule it is, 3.4, I believe, something like that. But so you have to be careful with how you use the information. The most valuable commodity that I found is not money, but I guess the second most valuable commodity, it's next to your one down from your health, is information. That's the most valuable.
Like you said in the last episode, information is power. Information
is power, because if I told you that Aetna or IBM or some stock was going to go up 10 points tomorrow, would be extremely valuable information, because the first thing that you do when we got off of this podcast is buy 10,000 shares of that stock, and it goes up 10 points, you make $100,000. So that's a hyperbolic example, but
yeah, no, do you have any tips like that for me, John? I'd appreciate it. I'm just kidding.
Even if I did, I don't want to go there.
What trends or changes in the legal landscape of business disputes and debt settlement do you feel that businesses need to be aware of, especially in where you are, Massachusetts and Connecticut?
Between the two states, there's not a lot of difference. I mean, if you were to say what's the difference, if you were to say Massachusetts and Florida, let's say, just again using an extreme example, or Connecticut and Florida. Well, the first thing is Connecticut has a homestead exemption, an exemption in the equity of your primary residence. So I believe it's $75,000. In Florida, you could have a $15 million house, and if it's your primary residence, no creditor can touch it, can't let you. Between Massachusetts and Connecticut, there's not too much of a difference. Connecticut makes it a lot easier as far as debt collection in terms of the procedural process once you've obtained a judgment to what they call execute on the judgment, which is a fancy way of saying getting your levying upon the debtor's assets to get paid on the judgment that you have. Judgment is just a piece of paper that says someone owes you money. So when you execute on the judgment, you're using the laws of the state that you're in to levy upon that person's assets to satisfy the judgment, whether it's their wages or their bank account or their personal property or their real property. Massachusetts makes it a lot more difficult procedurally. And I won't get into I won't get too Harvard on you and get into the technicalities, but it's really the difference in Connecticut between like 15 minutes or 20 minutes filling out a piece of paper, and in Massachusetts, they put you through a lot more procedurally, much more complex in Massachusetts.
Okay.
In terms of the laws with respect to debt collection, there's a federal law which obviously all states have to follow, the Fair Debt Collection Practices Act, which is 15 U.S.C. 1692, I believe. So every state has to follow that. Connecticut, Massachusetts, and all the other 48 states. If you're a debt collector collecting on a consumer debt, which is a debt, consumer debt is as opposed to commercial debt. Consumer debt is a debt that is where the money is used for personal, family, or household purposes. In terms of at the state level, both states have state laws that not only apply to debt collectors collecting a consumer debt on behalf of an original creditor, because the federal law doesn't apply to original creditors, but the state laws apply to the original creditors also. So it's more stricter laws. Both Massachusetts and Connecticut have those laws. And as far as the exemptions go, larger exemption as far as the homestead exemption in Massachusetts as opposed to Connecticut. Connecticut has a very relatively small exemption. Massachusetts, the homestead exemption is $500,000, $500,000 in the equity of your primary residence. So it's quite a bit more than $75,000. The biggest thing is really the procedural mechanism to execute and get your money after you've obtained a judgment. I don't know why. It's very archaic in Massachusetts. It's really they don't make it easy. So.
All right. Well, thank you for tuning into The Fixer with experienced attorney and author John Tatoian. To connect with John, you can visit jontatoianlaw.com or give his firm a call at 860-490-4138. And of course, don't forget to like and subscribe to our channel. John, great to see you again. Thanks for being here.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.